Ladies and gentlemen, a very good morning to you all. My name is Vikas Subaya, and on behalf of CMR School of Legal Studies, it's my absolute pleasure to extend a hearty welcome to each one of you present here. Honorable Chief Guest, esteemed dignitaries, professors, fellow participants, and my dear students, welcome to the one-day certificate workshop on legal aid lawyering. We are thrilled to witness such an eager audience and a highly learned speaker panel committed to deepen our understanding on this important topic. Hamara Samvidhan, Hamara Samman. To commemorate the momentous occasion of India's 75th year as a republic, the Department of Justice proudly inaugurated the Pan India campaign Hamara Samvidhan, Hamara Samman. This initiative is a resounding call to action for every citizen to actively contribute to shaping the vision of Vikshit Bharat by 2047, which is Bharat being a developed nation. Embarking on a united vision under this campaign, CMR School of Legal Studies, in association with Department of Justice, Government of India, and National Law School India University's Center of Environmental Education, Research and Advocacy, CERA, brings to you this day-long certified workshop on legal aid lawyering, where you will be learning about various dimensions of legal aid, schemes and campaigns of Department of Justice on legal literacy and pro bono lawyering, and how to effectively engage in community building and pro bono advocacy. The workshop will be conducted in 3 sessions until 2 p.m. and we will break for tea and a group photograph at 11 a.m. It is going to be a day of great learning for all, the day where we invoke the spirit of legal social responsibility in the lawyer within us. Let us commence the event by lighting the lamp of knowledge and offering prayers to the Almighty. I invite Ghana from second year BA LLB to render the invocation song and request our esteemed guest on the dais to light the lamp.
ಸಜನರಿಗೆ ಭಯವುನ್ಯಾತಕಯ್ಯ ಸಜನರಿಗೆ ಸಂಜೀವರಾಯರ ಸ್ಮರಣೆ ಮಾಡಿದ ಮೇಲೆ ಸಂಜೀವರಾಯರ ಸ್ಮರಣೆ ಮಾಡಿದ ಮೇಲೆ ಸಂಜೀವರಾಯರ ಸ್ಮರಣೆ ಮಾಡಿದ ಮೇಲೆ ಅಂಜಿಕೆಯಾತಕಯ್ಯ ಸಜನರಿಗೆ ಭಯವುನ್ಯಾತಕಯ್ಯ ಸಜನರಿಗೆ ಕನಸಲಿ ಮನದಲ್ಲಿ ಕನಸಲಿ ಮನದಲ್ಲಿ ಕಳವಳವಾದರೆ ಹನುಮನನೆನೆದರೆ ಹಾರಿ ಹೋಗದೆ ಪಾಪ ಅಂಜಿಕೆಯಾತಕಯ್ಯ ಸಜ್ಜನರಿಗೆ ಭಯವುನ್ಯಾತಕಯ್ಯ ಸಜ್ಜನರಿಗೆ ಪುರಂದರ ವಿಠಲ ಪೂಜೆಯ ಮಾಡುವ ಪುರಂದರ ವಿಠಲ ಪೂಜೆಯ ಮಾಡುವ ಗುರು ಮತ್ಮರಾಯರ ಸ್ಮರಣೆ ಮಾಡಿದ ಮೇಲೆ ಅಂಜಿಕೆಯಾತಕಯ್ಯ ಸಜನರಿಗೆ ಅಂಜಿಕೆಯಾತಕಯ್ಯ ಸರಿ ಸರಿ ರಿಮ ರಿಮ ದಪ ಮ ಪ ಅಂಜಿಕೆಯಾತಕಯ್ಯ ದಪ ಮ ಪ ರಿಮ ಪ ದಪ ಮ ಪ ರಿಮ ಪ ಅಂಜಿಕೆಯಾತಕಯ್ಯ ಸರಿ ಗರಿ ಸರಿ ದಪ ಮ ಪ ಗರಿ ಸ ಅಂಜಿಕೆಯಾತಕಯ್ಯ ಸರಿ ಸರಿ ರಿಮ ರಿಮ ದಪ ಮ ಪ ರಿಮ ಪ ರಿಮ ಪ ಸರಿ ಗರಿ ಸರಿ ದಪ ಮ ಪ ಗರಿ ಸ ಅಂಜಿಕೆಯಾತಕಯ್ಯ ಅಂಜಿಕೆಯಾತಕಯ್ಯ ಅಂಜಿಕೆಯಾತಕಯ್ಯ
Thank you, Zana, for the melodious prayer. I now call upon Professor Dr. T.R. Subramania, Dean of CMR School of Legal Studies, to render the welcome address, followed by presentation.
A very good morning to all of you present here. Knowledge has no limit. And being lawyers, you should have a knowledge of almost all the subjects. And you should be very skilled in the field of especially legal education. Legal lawyering is an important aspect which everyone as a student should study at a young age. With this view, the Ministry of Justice has been doing so much of work to produce quality lawyers in this country. And they have an understanding with the National Law School of India. And the National Law School of India, especially led by Dr. Sairam Bhatt at the head of the CIRA department, has been doing wonderful service. And that is the reason we also thought of giving a day's training program to our students. On behalf of the CMR School of Legal Studies and on behalf of the chairman of the CMR University and the chancellor of CMR University, I deem it a great privilege to welcome today's chief guest, Dr. H.P. Prabhakara Sastry. Dr. H.P. Prabhakara Sastry is the most learned man. He is an MA, LLM and PhD from the National Law School. And he was born in 1962 on April 4th and afterwards registered as an advocate in 1991 and became a district judge in the year 2002. And he became an additional judge in the year 2017 and became a regular judge, permanent judge of the Karnataka High Court in the year 2018 on November 3rd. And afterwards he had a checkered career and it was really wonderful. He had served as the Registrar of the Supreme Court of India. In addition to this, prior to becoming a judge of the the High Court of Karnataka, he had served as a district judge in different capacities in several districts. He has served as a district judge in Tumkur, served as a district judge in Bagalkot, served as a district judge in Chikballapur and in other areas as well. With this immense experience, both in handling the cases and in the scholarship, because he has earned a PhD from the National Law School, he is well known and is supposed to be one of the distinguished speakers as well. Sir, the university is actually honored by your presence. On behalf of the CMR School, I also welcome Professor Sairam Bhatt. Most of the students as well as the teachers, Professor Sairam Bhatt is not a new man. At least in a year, he will be visiting us 3 times. And 3 times when he visits, he will be delivering wonderful lectures. And most of these lectures are put on our website. Those who have not seen, those who are the first registered students can have a glance about this. As a teacher, he is well known. As a researcher, he is master class. And he has been conducting several programs in association with the Ministry of Environment and with the other departments of the government as well. Again, I sincerely welcome Professor Sairam Bhatt on behalf of the School of Legal Studies. Yeah. We have with us another learned professor, Professor Shyam Kishore. Professor Shyam Kishore happened to be the Dean of the Alliance Law School, Bangalore. He has served in different capacities, not only in Alliance Law School, as well as in Ramaya College of Law. Now, these days, he has a wonderful experience, got his degree from abroad, Singapore, and serving as a wonderful research scholar as well. Sir, on behalf of the CMR University, I deem it a great pleasure to welcome you. We have other resource persons as well who are sitting on the row. And on behalf of the CMR University, I just intend to welcome all of them. And the first person is Rohit Kamath. He is yet to come. He will be joining, and who is working as an advocate and company secretary. Then we have Mr. Vikas Gehlot, who is known to all of us, and he is a senior associate in NSI. And we have advocate J. Mohan is sitting here, and I've seen him serving in different capacities at the National Law School as the organizer of seminars and all, both of them. So once again, we are wishing you the best. Two of them, the speakers, resource persons will be joining through online, and they are Sheikh Hon'ble from the Ministry of Justice, the Law and Justice from the Government of India in the afternoon. And I will also sincerely thank them at this occasion. And there is another person, Mrs. Mahima Kera Sharma. She is also from the Ministry of Justice. On behalf of the CMR University, I welcome all of them. And it is my duty to welcome Professor Praneshwaran, because we are the ones who sit together and organize these functions. And I also welcome almost all the teachers, whether they are present here or inside the class. And last but not least, all of you. You have come with an intention to learn, and you should take it very seriously so that you will benefit, not me. Once again, with best wishes to all.
Thank you, sir. Further elaborating into the introductions, with the utmost honor and privilege, I stand before you today to introduce our esteemed chief guest, Honorable Dr. Justice H.P. Prabhakara Sastry, former Judge, High Court of Karnataka. Born on the 4th of April 1962 in Davanagere, Dr. Prabhakara Sastry's journey in the realm of law has been nothing short of exemplary. He embarked on his legal education at RL Law College, Davanagere, further enriching his academic excellence with an MA in philosophy and an LLM in international law from the prestigious Bangalore University. Dr. Prabhakara Sastry was admitted to the bar in 1991 and thereafter practiced law with distinction in various courts across Bangalore and other localities. His early career was marked by his commendable service as a standing counsel for undefended accused in the Sessions Court of Bangalore Rural District, reflecting his unwavering commitment towards justice. His legal expertise transcended national boundaries as he gained valuable experience in the United States of America, appearing before the federal courts in San Francisco and the Court of Appeals in the state of California. In addition to his practice, Dr. Prabhakara Sastry has been a revered educator, imparting knowledge as a guest faculty member at numerous esteemed law institutions, including the National Law School of India University, Bangalore. On the 27th of May 2002, he was appointed as District and Sessions Judge, serving with distinction in Kalburgi, Bengaluru, Bagalkote, Chikbalapura, and Tumukuru. His judicial acumen and linguistic prowess were recognized when he became the first recipient of Rajya Prasasti State Award for rendering quality judgments in Kannada in 2008. Dr. Prabhakara Sastry's illustrious career also saw him becoming the first district judge from Karnataka to serve as a registrar in the Registry of Supreme Court of India in 2011. His scholarly pursuits culminated in a PhD from National Law School of India University in 2014, with his thesis focusing on domestic arbitration and judicial involvement under the Arbitration and Conciliation Act 1996. Dr. Prabhakara Sastry was elevated to the bench as an additional judge of Karnataka High Court on the 21st of February 2017, and subsequently as a permanent judge on the 3rd of November 2018. His judgments have been lauded for the depth of legal insight and profound understanding of human nature and societal intricacies. Upon his retirement on 3rd of April 2024, Dr. Prabhakara Sastry has continued to illuminate the path for aspiring legal minds, sharing his vast reservoir of knowledge and experience with unwavering dedication. It is indeed a privilege to welcome you, distinguished Chief Guest, Dr. Honorable Justice Prabhakara Sastry. Please join me in extending a warm and respectful welcome as I invite Sir to address the gathering.
Professor Dr. Subramanian, Dean Faculty of Law of CMR University. Professor Dr. Shyam Kishore, Dean Faculty of Law, Alliance University. Professor Sai Rambhat, Professor and Head of CIRA National Law School of India University. Professor Kumar, the Senior Faculty of this Department of Law of this university. All the dignitaries, learned professors who have assembled here as resource person and the faculty of this university. My dear student friends, it is a special workshop today you are attending. Legal aid, lawyering. India has 140 plus crore population. %77% of Indian population is considered as literate. Literate does not mean educated. The basic literacy they are expected to know about reading their mother tongue, the alphabets, writing their name. Now that has been boiled down to such an extent to consider a person as literate, provided he knows writing his name, though that's not actually and exactly the terminology of literacy denotes. However, the fact remains that 23% of Indian population are even today illiterate. It is not a small percentage, not a small number. When we come to the question of legal illiteracy, the percentage is still higher. It's not even just 23, it is still higher. Then just imagine what we can expect from those people who are illiterate or legally illiterate, or though literate and educated, pretend as though they do not know anything about law and the law has got nothing to do with them, and they would like to lead their life as they feel like without bothering about the law and its intricacies. In India, we have to face the menace not just of legally illiterate people, even of those people who call themselves educated but still give least respect to law and obedience to law. The preamble of our constitution, as you are all aware, strive to ensure justice for all as its topmost priority. Having achieved the goal of justice for all is a question. Answer is very clear and obvious, not yet. Not yet. We celebrate this function as a part of Hamara Samvidhan, Hamara Samman. The first sentence of our Samvidhan, we the people of India having solemnly resolved unto ourselves to make sovereign, democratic, secular Republic of India and to ensure to all its citizens justice, social, political, economical. The very first objective of the Constitution is ensuring justice to all, social, political, economical. Rest of all the things follows later. But till date, till today, we hear people telling, no, I did not get justice. Where is justice? How to approach justice? Many people say we do not know what it is. No, our fate is like that. What to be done? Something probably karma is there of my previous janma. I have to bear with that, I have to suffer. We try to console ourselves. So probably you can hear me even without microphone also.
Yes, sir.
Yes. So that being the case, when we are unable to achieve the very first objective of our constitution, that justice for all, and crores of people are even today denied or deprived, so whatever you call it, from access to justice, is it not our failure which we should fairly admit and try to overcome from it? Yes, we have to. We have to, necessarily we should do that. Several measures, several steps, several efforts have to be done in that regard, in which legal aid lawyering workshop with respect to what is going on today after this inauguration is a part of it, in the direction of achieving the objective of the preamble of Constitution of India. The reasons for not achieving that goal of justice to all are several and various. First and primary is illiteracy. For this kind of population of 140 crore plus, and this topography, different culture, economic imperative, this is quite but natural, but it doesn't mean that we should maintain with the same and manage with the illiteracy. Absolutely not. Apart from illiteracy, legal literacy also is a point to be considered. Illiteracy must be removed. People must be made legally literate. Because our administration won't go further without embracing to the principle that ignorance of law is no excuse. All said and done, even myself may be unaware of several of the legal provisions or laws. When a matter comes before a judge, even though the subject matter is strange to him, he will prepare himself, he will study and then take up the matter for trial or adjudication. But hardly anyone can say that I know every law of the land. For that matter, many legal luminaries may not be able to say as to how many statutes are there in force in India as on date. A topmost officer in the Ministry of Law and Justice also may not be able to tell or give exact statistics immediately. Yes, it's quite natural because we have the laws in abundance. British made laws are still, several of them are in force. So that being the case, illiteracy is one such aspect which prevents a man from having access to justice. The second one is poverty, financial difficulty. All said and done, though justice for all is one of the primary objectives of our constitution, but even today, millions of people are deprived of that justice because they are unable to meet the legal expenses because of economic poverty. The court fee probably is one among the lowest in Indian judiciary compared to the other countries in the world. For any criminal matters, absolutely no court fee at all. Even for a writ petition, only 100 rupees is the court fee. For bail application, no court fee at all. Civil litigations also, Some are fixed standard court fee of 25 rupees and above. Not even a cost of a coffee or tea what you take in coffee break. That is the court fee for the entire litigation in a particular court in the original jurisdiction. Still, the other legal expenses, including the professional fee and incidental expenses, several of the people are unable to meet it. Bear with that. The poverty percentage in India, though it is reducing year by year, still we have at least 3% of our population below poverty line, who doesn't even have an annual income of rupees 27,000, not monthly, annual income of rupees 27,000. If that person has got any problem for which he requests a legal redressal, he is totally unable to bear the legal expenses. The third one is the lack of accessibility to lawyer. Several people cannot afford to consult an advocate, legal expert, even for an advice. Unable to meet the legal fee. Several of the people are not aware whom to consult or whom to approach. That is also one of the ignorance which our people are suffering. There are also specialization in law. No doubt, generally an advocate entertains all types of litigations and deals with all types of litigation in all different hierarchy of the courts, fine. But the days are changing. Even among the advocates also in practicing, there are specialization. And the advocates are confined to one particular type of practice. The litigant would not be known. For a simple motor vehicle accident case, he may approach an advocate practicing on the criminal side. For an eviction suit, he may approach an advocate practicing in service matters or tax laws. Some advocate may direct him to another advocate, some may not, and they may collect some legal fee, even to divert him to another counsel or another advocate. But this poor litigant may have to spend a lot in having access to an appropriate advocate or lawyer. Instead of what he thinks, let it be, do not know anything about that. This small inconvenience or loss I would suffer, let me bear with it. That attitude, that let it go, whatever happens, let it happen, is quite common among all in India. Fourthly, non-availability of details of opponent who is intended to be sued by a person. I suffer an infringement of legal right by a third party. A person may be every morning while going for a walk, throw some garbage in front of my house and goes. That is the easiest way for him for disposal of the garbage of his house. Even today in Bangalore, that habit is there. Several of the so-called educated people does it. They do it. In the early morning itself, their garbage put in a bag or other thing while going, they just throw it in front of the house of somebody else and go. These kind of nuisances I suffer every day. I want to take appropriate action. I do not know whom I have to sue. I do not know the details of that particular person who is causing nuisance every day to me. He is not bothered to disclose his identity, rather he speaks in a rash and indecent manner when questioned. I do not know to which authority I have to sue. I go to an advocate, the advocate would say, authority I can identify, the Brihat Bengaluru Mahanagara Palike, you have to arraign as one of the opponent or the respondent or the defendant, that you don't worry. But that particular person who is every day causing nuisance to you, it is for you to secure his details and furnish it to me so that we can arraign him as defendant number 1 or respondent number 1. I am unable to get those details. Consequently, what I do, let it be, chalta hai, jane do, kya karna? I leave it. So in that guy, for that reason, some more litigations won't go to the court of law or before the appropriate authority or forum. These reasons are very simple, but collectively they come out in large number. Fifthly, the most important reason is of delay. We all speak in all public platform while speaking about the dispensation of justice. We say justice delayed is justice denied. Yes, delay is the greatest meaning. Everybody speaks, but what effort is being done by us to curtail delay? We should have some introspection. Till all said and done, every matter gets delayed in the court of law. Very recently, couple of days back, I read in the newspaper a trial court, a session judge's court in Delhi is yet to pronounce order on an application challenging framing of charge on an additional charge sheet in a matter of 1984 Sikh riot case. Accused therein, one among the accused therein is a prominent politician. From the year 1984 till the year 2024, in a criminal matter involving killing of Sikhs, the court is yet to decide, is it appropriate to frame charge on an additional charge sheet or not. Look at the pace or the speed, how we are going. 40 years charge itself is not framed. Then you expect what further time it would take for the trial, several applications coming in between, orders challenging those orders, ultimately reaching or coming out of the final judgment in the matter. So delay is the greatest menace. Sixth one, the reason for not approaching the court or taking the legal action against errant person or the threat by the opponent. Threat, fear of injury. If you go to the court, I will see that your entire family is removed. If you lodge a police complaint, your daughter against whom the alleged offence is said to have committed would be no more. She will be extinguished. These kind of attitudes or the acts threatening the complainant and his family is also becoming common in several of the matters, which also deter them from approaching for legal redressal of their grievances. The seventh reason is fear of loss of reputation and honor of the family. A female member in the family has been molested or attempted to be molested, or some injustice has been caused against her. reputation. The family itself hesitates from approaching the court of law or taking suitable action on the guise that no, if we go, it is ourselves will be making public that my daughter, my sister, or my lady member in the family has been tackled by another person and she has been molested, her reputation is at stake, our family's reputation is also at stake. Therefore, better to forget it. Instead of, we will advise our sister or our wife or mother, whosoever it may be, not to come home a bit late, reach home before 6 o'clock in the evening, don't go out of the home before 6 o'clock in the morning. We restrict our freedom, we curtail our liberty, but we hesitate to take an appropriate action which as a citizen we are required to take in the best interest of society against the culprit or the accused. There is the social circumstance in the society, what protection they get if they take any action, or all incidental aspect they have to be looked into and discussed. But this is also one of the reasons of the people not approaching the court. The eighth one is not getting adequate protection. In several of the cases, the victim or his family members or eyewitnesses would be ready to take legal action against the accused or the culprit, and you have to go to the court and give evidence. The eyewitness is also ready. He says, yes sir, I saw. He took out a chopper in public and massacred that lady. He gave 4 blows. I myself attempted to rescue that lady, but I couldn't. When the question of he coming to the court and giving the evidence comes, he says, I can come and give evidence, but what protection is there to me and to my family? The culprit is a known accused. He won't hesitate to eliminate my family. The court made the best say, yes, Mr. Prosecutor, look into that matter. Do needful. What happens thereafter? Probably you would have read in the newspaper 3 days back. A serving public servant in a government department rushed to the open court and pleaded to the judge, give me protection. I have been threatened by a deputy superintendent of police and his team because I initiated an action against them. I brought to the light their act of corruption. They are threatening me day in and day out. They are going to hoist false cases against me, and somehow they have put me behind bar. The meantime, by the time he approached the court and pleaded, as per the newspaper report, a couple of criminal cases were already lodged against him. A charge sheet also came to be filed in an urgent manner, alleging that he was involved in drug trafficking because a small quantity of ganja was found in his possession. Most easiest way for the police to book a person. What the court did? It directed the additional state public prosecutor to look into the matter and to do needful. Simultaneously, it also cautioned the person who had approached the court that in case if his statement is wrong, it will be properly handled in accordance with law. Our machinery, our style of functioning is like that. Sitting as a judge, nobody can know and decide then and there itself who is right and who is wrong. Was there a real true threat to him posed by the so-called the police person, or is he falsely making those allegations? Cannot easily be jumped to conclusion. But if his allegation is true, look at his plight. Several such incidents, probably you too might have been witness or witnessing in public life day in and day out. Day in and day out. Our system, our functionary, take some time to react appropriately. Sometimes they react appropriately, sometimes they don't. Consequently, what happens? Even after seeing something happening, even after suffering myself of some injustice, legal infringement of right, I try to forget it, console myself, and ultimately my neighbors themselves advise me, no, you should adjust with them and go. That is life. You cannot be so meticulous. Yes, that adjustment word. One particular word like sorry, mistake, this adjustment also being used rampantly in India, forgetting what its sacred meaning is. For everything, adjust. The next aspect is the belief of victim or complainant that the accused may come out on bail immediately or within short span of time of lodging the complaint, in which an event the very purpose of lodging the complaint will be frustrated. Though it is totally a false reason for not approaching the appropriate forum of the court to initiate legal action against a errant person, but still, large number of people have that. You can ask your own neighbors stories if you find time of some incident has happened, some criminal acts or some criminal offense. If you ask them, why you do not lodge a complaint? They would say, what to do, sir? Even if I lodge a complaint and if the police take them in third day or fourth day, he will be back and he may attempt to take revenge against us. So, it is wastage of time on my part. According to him, once he has suspected an accused, he is the culprit, he is the offender, he must be kept behind bar forever. Absolutely, that is not the spirit of law, that is not the justice. Still, that belief is common among several of us. Therefore, thinking that even if I lodge a complaint, ultimately it is of no consequence, the accused would be scot-free and he may attempt to take revenge against me. Therefore, why should I go to the court of law? That is also one of the reasons for not approaching the appropriate forum, authority or court, rather than feeling oneself to be happier, satisfied with suffering what he is suffering with. The next point, 10th point would be, there is no guarantee that the judgment, decree or order of the court will be honored by the other side. This is becoming more and more common in these days. I have lent 10 lakh rupee to a person, he has not returned. Ultimately, I file a money recovery suit against him. That will take few years or decades. Though not myself, at least my children would get a judgment and decree in their favor. Pay Mr. Shastri or his legal representative 10 lakh rupee with interest at the banking rate. Even though the decree is drawn in my favor, what guarantee is there that the judgment debtor, the sufferer of the decree, would honor that decree? For getting that judgment or decree or order executed, then once again I have to rush to the court by filing execution petition or contempt petition as the case warrants. Some more time is wasted. I have to incur more legal expenditure. So better to negotiate and compromise with him. Fine, you have borrowed 10 lakh rupee, including interest, now it has come to 16 lakh rupee. How much would you pay? He says 6 lakhs rupees. I have paid him 10 lakh. Present liability is 16 lakh. He is offering me 6 lakh, that too in installment. After some haggle, I agree for 8 lakhs in 2 installment. I am happy. So I choose accepting a smaller sum, a small sum than what I deserve legally in the case of compromise, than going to the court, suing him and fighting a legal battle against him. Why it is happening? We say justice for all. We have different forums for our legal redressal. But still, in society, in practice, this is what is happening. This is what is happening. The 11th reason and the last reason is that the multiple opportunities to the party to a litigation to approach higher courts in the form of appeal, revision, review, etc. Yes, if not this trial court of original jurisdiction, if not municipal court, I go to district court. If not district court, I go to high court. If not high court, I go to Supreme Court. Multiple hierarchy, I have opportunity. Instead of paying him the money or admitting my guilt and say, consoling him legally with what he is entitled to, I prefer continue to dispute in the court. Why? My ego comes in the way, or his ego comes in the way. I don't mind spending more than what my liability is to him, but somehow I should see that he is put into some inconvenience, some deal. For that matter, practically, you may not be aware, in several of the matters, whether civil or criminal, more than what the main issues involved or the questions involved in the dispute, the ancillary points, they gain importance. For every smallest thing, an application would be filed, some order would be attracted, that order would be challenged. Not satisfied, go to another hierarchy, another court. In a small matter, someone is ordered against me, imagine. Rather than putting my attendance in the court, contesting the matter by engaging the services of an advocate and contesting the matter, I will be advised to challenge that order of summoning me to the court. Why they should summon me? Yes, summoning of a person unnecessarily is also putting him to some inconvenience. That also curtails his right. Our constitution says, its interpretation says, I get an opportunity. Challenge that order of issuance of summons. My application is rejected. Go to next court. Invoke Article 226 of the Constitution. Part 3 of the Constitution, my fundamental rights, how they are infringed. Yes, several months or years together would be lost in that state. Ultimately, if the proceeding is crashed, fine, I am happy. If not, I come to the court and I say, yes, I am Prabhakara Sastry, but the person whom you intend to summon is A.D. Prabhakara Sastry, I am H.V. Prabhakara Sastry, therefore I am not that person, discharge me. Another battle, another round of litigation from trial court up to high court, or sometimes even up to Supreme Court. Every stage on every application, some appeal, some revision, some review. If the litigant is economically well, probably as common people normally comments, there will be more number of interlocutory applications or the appeals or revisions on interim orders. The lawyer also would be very busy with more number of briefs with him. Consequently, there will be enormous delay in justice, By the time several of the witnesses either will be living or alive or not alive, evidences would be vanished. Evidences would be vanished. Several of the people would lose their interest. Take a simple example. A girl going to a college has been molested by a person on the road. He files a police complaint. And that chap, that accused is an influential person. He files application seeking quashing of the proceeding or his discharge, etc. Case goes on 6, 7, 8 years. On that application issue, whether he is to be summoned or whether the proceeding is required to be continued or quashed. After several exercises of these kind, ultimately one fine day, the matter is ripened for trial. The girl is summoned to come and depose evidence. The defense counsel asks, yes madam, on that day you are going to the college, what type of dress you are wearing, of which color? You said he tried to pull the dress you are wearing, how many buttons it had, what type of button. What that girl could answer? She says, I don't remember. Yes, you don't remember, right? Yes, I don't remember. Why you don't remember? Because it is 14 years back this incident, according to you, is happened, right? Yes. Since a long lapse of time has elapsed already, 14 years, I am unable to remember that. Yes. Then, yes, fine. It is very difficult to remember of any events or incidents of such a old time, right? Yes. Normally, 2 months, 3 months, 4 months we can remember well and correctly, right? Yes. Years together, it is very difficult. Yes. That too 14 years, Sita Vanavasam is too long, right? Yes. Fine. Then she speaks something, he says no further cross-examination sits. In argument he says, that victim has admitted several of the suggestions that she cannot remember beyond 2-3 months. Year or two is very difficult to remember. She herself has admitted 14 years is too long a time. Hardly anyone remembers the details or particulars of any event. She doesn't even know what dress she was wearing on that day. Then how can she say that he did a particular act in a particular manner? Benefit of doubt is obviously required to be given to my accused. Rather in this case, it is a false case hoisted against my client to spoil his reputation because he is too rich a person, wealthy person. This girl wanted to blackmail him. Look at how it boomerang. This is how the proceeding goes. This is how the proceeding goes. Sitting in the classroom, you write Bharatiya Nyaya Samhita, Bharatiya Nagarika Suraksha Samhita, Bharatiya Saksha Adhiniyam. How they practically work in the court of law. This is the way. This is the way. It is here your role comes. Role comes of lawyering, particularly legal aid lawyering. Legal aid lawyering. In classroom, by these professors, you learn what the law is, because that is very, very essential. Without knowing what the law is, you cannot know how it works. You must be very clear, very thorough as to what the law is. But in practice, how it works, how it has to be put into service, how it has to be applied, that experience you get once along with your studentship during your law degree or postgraduate degree, you also spare some time for legal aid services, legal aid activities. That will not only help the society to some extent, that will help you a lot more than what society gets, you get. You get more practical knowledge, more experience, a clear picture of how our system is working, where we are heading. For that, it is very much necessary. Merely because, yes, I am a member in the legal aid, I help so many people. In our college, this month we entertained 17 complaints and we answered. Fine. That is one part of it. One part of it, yes, you have helped 17 persons or 17 families with your legal advice. But all those 17 complainants or the victims or the injured persons have helped you to gain more knowledge, both academic and practical. Academic and practical. Therefore, you should not only give, according to me, a free legal advice or a legal service, but you should also offer them a coffee or snacks or lunch, because they too are your teachers. They too are your teachers. Only when you learn from each one of your client, each one of the litigant, you get a valuable point, a lesson that will enrich your knowledge. That will enrich your knowledge. Therefore, this legal aid lawyering, don't be under an impression that no, we are doing something special service to the society. We are great. No. Society is giving you an opportunity to learn more, to understand the society better, and to stand on your own legs as a renowned advocate or a renowned judicial officer or a renowned academician. So be grateful to the society, to the system, because that is giving you an opportunity. So what you are now expected to do? Volunteer to do legal services. Volunteer to do legal services. In addition to classroom teaching, I get also further education or teaching by the common people through my legal services. My legal services. Section 2C of the Legal Services Authorities Act 1987 defines legal service as including fighting litigation in the court of law or authorities, and also legally advising person. So legal services includes legal advice that you as a student of law can easily, comfortably do. Unless you get a law degree and enroll yourself in bar council, you cannot practice in the court of law. But as a student of law, there is no prohibition for you to give legal advice to the needy person after yourself becoming thorough and clear of the provision of law upon which you are expected to give advice. So that you will study law, get expertise by yourself, acquire more knowledge or required knowledge at least, and then you advise them properly. NALSA, National Legal Services Authority, was constituted with that aim, that purpose, to achieve the objective of access to justice to all the people in India. Thus, to achieve the primary goal, primary objective of our constitution, justice to all. It is through NALSA. Long back, a circular was issued with the form of a request, which was circulated in every state through the State Legal Services Authority, including Karnataka State Legal Services Authority, mandating every educational institution, not necessarily law colleges and law schools, every educational institution to form two clubs, legal aid club and a legal literacy club. That was compulsory. When that circular was issued, I was serving as principal district and session judge in the district of Bagalkote in the northern part of Karnataka. I ensured that all education institutions, both government and non-governmental, including private medical colleges, form these two clubs, legal aid club and legal literacy club. Legal aid club, legal literacy club would comprise of the student members. The students themselves will form that. Not less than 8 students from the institution in each of these clubs. They will be assisted by one of the in charge teacher or the professor. In turn, they would be assisted or imparted with knowledge by the local legal services committee. which is functioning within the premises of the local courts under the aegis of the local judicial officer. They will come and try. This is a legal aid club. Will entertain the grievances of the common man and assist them in getting legal aid. They properly guide them. Yes, your husband has left you, deserted you. He is not paying you any maintenance. You are only a housemaker, illiterate. You have 3 children who are too small and going to school. Your husband is not paying a single rupee to you. Don't worry. You have got right to claim maintenance from him. We will arrange you for that. There is a court in Bengaluru, city civil court, you go there, or Mayor Hall court, you go there. In the court premises, you find a board. Kanunu Seva Samiti, Uchita Kanunu Arivu Nerevu Samsthe, Free Legal Aid and Free Legal Literacy Center, Legal Services Committee, Bengaluru. You approach there. There will be an officer in charge called a member secretary. He will assist you. They will give you free legal aid. You need not have to pay even a rupee to any advocate. The legal aid will have member of a panel of advocates as its member. They will take up your case free of cost. They will file a case, complaint, suit, whatever may be as the circumstance warrants, without expecting any money from you, and they are not supposed to. It will totally free of cost. Go there, make use of it. Every woman, irrespective of her religion, place of birth, economic standard, she is entitled for free legal aid. Educate them. You are giving free legal aid to them. You are giving free legal aid to them. Why not a disaster? Kerala. This legal aid team goes there. Maybe your college, CMR University School of Law. The legal aid committee members visits Wayanad. They establish a camp there for a week. Listen to the grievances, sufferings of the people, and they find out the best possibilities. Yes, you are entitled for this compensation under the National Disaster Scheme, State Management Disaster Scheme, the insurance coverage, or Prime Minister's Relief Fund, or Chief Minister's Relief Fund. You are entitled for this. An application is required to be submitted to the local Tashildar or the Deputy Commissioner, as the case may be. You don't worry, we will drop that application. Give us the particular, whom you have lost, who are suffering, who are injured. Legal aid you are giving. You get the information, you see the disaster, you know how the situation is, what the life of a human being is, how much of suffering. Try to reduce the suffering, eliminate the suffering. You are learning more. You are putting your education, academic knowledge to a practical test. How best to convince them? To how many people you could be able to secure some relief? That is your achievement. Beginning steps for your good advocacy. Good advocacy. So like this, from where you are sitting, you can do, going outside of your university premises also you can do enormous opportunity. Not necessarily to Wayanad or Uttarakhand, within Bangalore itself, within this Bharati Nagar, Fraser Town or the OMBR layout, here itself. How many residents in OMBR layout are aware of legal knowledge and legal literacy? Many are not. For a very simple thing of obtaining a driving license or registration of birth and death, people are not aware. People are not aware. Educate them. Take a survey. Educate them. Print, publish a handbills. Distribute it along with the newspaper for your grievances on the simple matters in law. Approach OMBR University School of Legal Studies on every Friday between 2 p.m. to 5 p.m. or every evening between 4 to 6 p.m. Excellent. Make a panel of student advisors. Monday it is your turn, Tuesday my turn, Wednesday your turn, 2 to 3 students sit there in one particular place. For a Korean section you have reserved a place there. I just know sir, while coming. Why not for free legal aid? Instead of helping a foreign university or showing some collaboration, why not to build India? Have a small portion earmarked for legal aid and legal services. Practically, actually, with whole heart, help them, give them advice, show them the several avenues how they can get legal redressal without spending unnecessarily the excess of expenditure or money. For lifetime, they remember the university, law school, and you. As a student, you can do that. Legal literacy, the another wing of the legal aid concept. Yes, in your area, the people are not aware about the environment. Road appears to be good, but look at the garbage. No proper cleaning. The environment is totally polluted. Take up that aspect. In the every corner of the road, or at least the alternate corner of streets, one Sunday afternoon, between 5 to 6, for 1 hour or 40 minutes, arrange a small lecture. Request the residents of that area to compulsorily attend to that. Invite the local corporator, because if the local corporator comes, several of the people will come. At least to give in to their difficulty, not interested in your lecture, but they will be forced to listen to you first. Spend 50 rupees to garland that corporator. You have 500 persons gathering. Tell them what nonsense they have created in their street. If they have to be little bit disciplined and concerned, how best their street would be, how best they can contribute for a better environment. Tell them what the law is for any environment pollution or even of a smallest nature. What would be the legal consequence? Yes, legal literacy you are doing. Legal literacy you are doing. These are not on the book. I have practically done this for decades and succeeded. Wherever I have gone in several of the district as principal district judge, I have made it. Every weekend I used to reserve, dedicate for these services. Legal aid, motivating the students. Legal literacy, I myself used to go and deliver lectures, educate the people to the maximum possible extent. At least 1 or 2% out of the population, if they realize, that is sufficient. But you get a good result, good response, good reputation to the institution. Therefore, legal aid, legal literacy are two major tools which you can make use of, being students in achieving the goal of legal aid lawyering. This is what the legal aid lawyering requires. For that, you have got a good study material also. Several of the aspects you will be discussed with in the coming sessions. Take a very simple example of registration of FIR, First Information Report. Look at the plight of the people. Anything is done, okay, they can lodge a police complaint, no problem. And police would investigate the matter. And if there are materials, they would file a charge sheet against the accused, accusing him of committing certain particular offences. You don't worry, the rest of the things the state would take care of. But have you ever seen the plight of a victim or a sufferer or a complainant in lodging a complaint? Probably you have not. Probably you have not. Go to a police station, maybe your own jurisdictional police station. Attempt to lodge a complaint. I was coming in my metro, somebody has taken away, snatched, say, my cell phone. I want to lodge a complaint. I have seen that girl who, say, committed theft. Before I could catch her, she ran away. I know her description. I inquired the people there. The security guard has said that girl daily comes and she does it. She is a regular thief in that metro station. This is my experience. as a judge, the police will scan you thoroughly, which even a CT scan or MRI scan won't do. They would ask every nonsense question to you. What is that phone? Where did you buy it? How much you buy? You say you are a student. How could you be able to spend 28,000 rupees for that mobile set? What is your father? He is a second division assistant in a department. How he can get 28,000 rupees cell phone to you? What is his monthly extra income? What is his monthly extra income? What is his your brother? Oh, he must be a gunda loafer in his college. All these things, you feel hurt a lot. Ultimately, with all greatest patience, if you answer them all fully, that station house officer, very old Buddha Admi, promoted as a head constable or ASI, he is good for nothing, would be made a station house officer there. He would say, wait, let inspector come. You say, I have come with a pre-written complaint. You accept this complaint, give me acknowledgement. You say, are you teaching me what to do? Sit there. Yes, where is your inspector, sir? You will be shaky in your voice now because he is showing his police style. Where is your inspector, sir? He says, you keep quiet. Is it your business? That's good. And if once again ask, he is in SP's office for some meeting, to entertain, to receive a small complaint of theft of a cell phone, with all the particulars, details, evidences you have, he won't register it. Ultimately, in the afternoon, the officer of the station, who is supposed to be there 7 o'clock in the morning, comes to the police station, calls the constable, and gets some snacks, coffee, etc., takes a small nap of 10 minutes and then asks who are they. And then they will call you. This person says, go, stand there, whatever he says, say yes and come out. Don't show all these intelligence what attempted to show before me. Yes, you further won't stand like this. And says, sir, my mobile theft. He told, station house officer, don't eat my head. All this nonsense fellows. Whatever he said, do that. Hey, you have an endorsement, Kodappa. Give him an endorsement or give her an endorsement. Fine. Take that endorsement and go. NCR he has given. Without you giving us the detail as to who the theft is, how we can find. Thousands of cell phones would be stolen in Bangalore. Do you think we have no other job except say searching for the thief who has stolen your petty 28,000 rupees cell phone? Better students don't have any cell phone. He advises you, don't use cell phone, be obedient to your parents, be a sincere student. Except stating that, leave a jutti and wear panche and go to classroom. Every rest of the things he says, advises and says, oh, you go. Feel, make it a point of visiting the police station, which is also in the curriculum of law studies in every university, including CMR University, probably. Not just jail visit. Whether you do jail visit or not, make police station visit. Sit there for a day. Know how it functions. Then you will come to know importance of registration of FIR. Ultimately, go to a court, take out 100 criminal cases. You will be surprised, astonished, or shocked to see complaints in all in 100 cases are similar type. I Basavva, Kom, Chenna Basappa, 56 years, resident of Konena Agrahara, do hereby state that I am Hindu by religion or Muslim by religion or so-and-so by religion, have one husband, 4 children, who are aching out their livelihood. My husband is a drunkard. He always beats me. Yesterday evening, while I was going, my cell phone was taken away by somebody. It fell down on the floor. Before I could lay my hand to take it up, the other person took it away and ran. I request your kind self to find out the culprit and secure me my cell phone back. Every complaint starts with his identity, father's name, husband's name, sex, age, religion, the family background, and one or two sentences what happened and what he wants to. You wanted to say more or say less. No, no opportunity for you. Why? The station house officer says, that's not complaint. You take down what I say. Write it like this only. Only then it would be complaint. It's a basic thing. Giving the complaint is the domain of complainant in whatever manner he feels like he can give. He can even say, every morning I get up at 8 o'clock in the morning and take 2 cups of coffee, one after another. Only then I go to gym. Yesterday also in my routine, when I was going, somebody snatched my cell phone with so-and-so details. He was like this. He doesn't entertain that complaint. He says, write me how I say. Educate the people. What is complaint? Educate them of their right. Literate the police that they cannot deny receiving the complaint merely because it is not there in the style and the manner and the format what they expect from a person. This is what as law students we can do. If an advocate does it, he may expect return. Where is my professional fee? Why should I do that? No. As a student, it is your duty towards the society. Do it. You learn a lot. It is one simple example. Like this, several of the topics you have today, in each one of the topic, these kinds of large number of, say, the do's and the don'ts as a student of law. In legal aid lawyering, what you can do would all be probably imparted to you in the coming sessions of this workshop. This is a very good endeavor initiated by Ministry of Law and Justice, National Law School of India University and CMR University School of Legal Studies. And I am fortunate having been invited today to address you all and share my thoughts today with you. I wholeheartedly have inaugurated this session. I wish the workshop grand success. I thank organizers for inviting me to this function and giving me an opportunity to share some moments. Thank you.
Thank you, Dr. Prabhakara Sastry. That was an exhilarating speech, and combined with all the best practices that you have given us, I think it set the right mode for this auditorium. On this light occasion, I would also like that CMR is going to unveil Kaleidoscope, our biannual newsletter of CMR School of Legal Studies. I will request our dignitaries on stage to please unwrap the first form. So Kaleidoscope is a biannual newsletter published by the School of Legal Studies, presenting the various events and accomplishments of the school in the preceding semester. The current edition showcases all the events and highlights conducted between Jan and June of 2024. Dear audience, humbly requesting your patience. It is with genuine delight and respect I introduce our second guest for the morning, Dr. V. Shyam Kishore. Dr. Shyam Kishore is a distinguished academic and a legal expert who has made significant contributions to the field of law. He earned his PhD from the prestigious University of Madras, focusing on a critical and timely topic, law relating to derivative action and protection of minority investors, a critical study. His academic journey also took him to the National University of Singapore, where he completed his LLM in Corporate and Financial Services Law. His academic excellence was evident early on as he secured second rank during his graduation in BA LLB Honours from the School of Indian Legal Thought, Mahatma Gandhi University, Kottayam, Kerala. Dr. Shyam Kishore possesses over a decade of teaching experience at both undergraduate and postgraduate levels. His expertise and passion for teaching have benefited students across various universities in India. He specializes in corporate and commercial laws, bringing clarity and depth to complex subjects. His areas of research include corporate governance, contract law, legal theory, reflecting his broad and profound understanding of the legal landscape. In addition to his teaching and research, Dr. Shyam Kishore has an impressive record of publications. His work is featured in numerous national and international journals, including those indexed by Scopus, showcasing his dedication to advancing legal scholarship. We are incredibly fortunate to have Dr. V. Shyam Kishore with us today. His insights and experience are invaluable. Please join me in extending a warm welcome as I invite Sir to address the gathering.
Good morning. Hon'ble Justice Dr. Hosur Prabhakara Sastry, esteemed and revered Dr. Subramanya sir, friend and mentor Dr. Sairam, Professor Kumar, eminent members of the faculty of the School of Legal Studies, Team Sira, and my dear friends, I shall strive to keep this as short as possible. I know we are running late behind schedule. But at the outset, let me express that I'm delighted to be in this August gathering, and I'm deeply honored for having been bestowed with the opportunity to sit with these, eminent personalities here. And also delighted because this is my second opportunity in very close period where I had the opportunity to hear the learned justice speak, because we were also fortunate to having been graced by his presence at the Lions School of Law when he came there to inaugurate the new batch of 2024. And the pleasure is the same, sir. Let me, quickly try and articulate what I had to tell you today in probably the next 4 or 5 minutes. The meeting today, this discussion started with Hamara Samvidhan, our constitution. And I'm sure students of constitutional law here would have been told on how our constitution was being drafted, how the contemporary times of those days, the global developments of those days had in many ways influenced the making of our constitution, right? The culmination of the World War and the making of the UDHR, declaration of the UDHR, and so on and so forth, all had its. You were, I'm sure, certainly told of that. But I would urge you all to go pick up the Constituent Assembly debates. Read through the discussions that happened in the making of our Constitution, in the drafting of our Constitution, in the wording of each and every provision. And then see, did those discussions actually, reflect the philosophies of the West? Did they reflect the philosophies or the discussions that happened in the world at that point in time? And it would be interesting to see, perhaps is not the case. What was discussed during those times? The philosophies of Rajaram Mohan Roy, Dayanand Saraswati, Ramakrishna Paramahamsa, Swami Vivekanand, Gandhi, Nehru, and Tagore. And most of those provisions, when you see the debates and the philosophies that were being discussed there, it was these personalities. I remember, my dad refers to these 7 people that I mentioned as the New Age Saptarishis. The Saptarishis that had a, significant role in the society that we are today. The society that we are today was shaped by the constitution that we had. And that document was drafted. So these concepts that were there, as the learned justice was enunciating, that are enshrined in our constitution, were not just given by an alien system or an alien legal system. It was always inherent in us. These constitutional law makers saw the constitution as the sacred tool in social transformation. We required that because at that point in time when we became independent, we were at its lowest ebb. A wonderful civilization that ruled the world at a time was at its lowest ebb, and these people were entrusted to bring that social transformation and regain our glory. And this tool, this document, was that tool that could bring about this social transformation. That was 1948 and 1950, my friends. But today, in 2024, when we look at it, we are supposed to be teaching law in law schools. But somewhere down the line, there has been a disconnect, as the learned justice was referring to. Law schools primarily have shrunk to just teaching what the law is. And that is where I commend Dr. Sairam and his team for being pioneers in trying to reshape, reinvigorate legal services as part of the sacred job which every legal institution was supposed to do. And this was not an extracurricular activity. This is not, you learn the law and then give legal services. This is learning the law. Our Gurukula Sampradaya never had legal services or experiential learning as a separate part of the curriculum. That is how they learned. They learned through experience. And unless, as what the learned judge was referring to here, unless you go to these places and how you see law in action, only then you learn the law. And legal aid lawyering, what does it require? It requires a couple of things. One, yes, it requires public spirit, a sense of responsibility to the society that you live in, that you comprise of, and the skills. Today's workshop is intended to give you those skills. To do what? As he was referring to, again, I constantly keep referring to because his was a very comprehensive speech. Access to justice, providing access to justice, reducing systemic inequalities that are existing in our society, and holding authorities and powers in the society accountable. Young friends, that is what you need to do. That is your duty that you owe to the society. And I'm very confident that the rich resource persons that we have today will familiarize you with the skills that are required for legal aid lawyering. And my job here is to kindle your public spiritedness, the sense of responsibility, to understand that a Viksit Bharat can only be attained when each one of us understand our responsibility and use these tools, including the law and the constitution, to bring about that social transformation. Don't expect somebody else to do that for you. We won our freedom, we won our liberty because every average man in the society stepped up to that. And that hard-earned liberty and freedom is protected only by you folks. I therefore urge you all to take this up, and I congratulate CMI School of Legal Studies also in partnering with Dr. Sairam on this initiative, and I wish you all the very best. Thank you one and all.
Thank you very much, Dr. Visham Kishore. We from CMR School of Legal Studies will ensure we at least take a positive step. I now request Professor Dr. Vijay Praneshwaran, Director of CMR School of Legal Studies, to render the vote of thanks to our esteemed dignitaries.
Dignitaries of the dais. Before I venture into my role as expressing our gratitude and niceties, I was taken aback 28 years back. I am Justice Prabhakara Sastri's student. He taught us special contracts and insurance. Sir doesn't need a mic. We used to be about 100 in the class. The gestures, the articulations, and if you notice the examples, Shastri will always be the example. Sir, if I may, it was always used to be ABC Batu Shastri. Some always used to be Shastri. The examples that he used to give. In fact, one of my faculty messaged me telling that sir is speaking like you. I said, no, I speak like sir. I have imbibed a lot from you, sir. The gestures and the examples I teach, giving live examples. That makes them remember. It was very nostalgic. In fact, when I got to know that the sir was selected as direct appointed district judge, I was very happy that a good teacher is becoming a judge. But then I was a little disappointed that the legal education is losing a good teacher also. On that note, you are very, very, very fortunate to have heard a very articulate, and not to mention of that smile. That's the icing of the cake. On that note, we are very fortunate to have heard Dr. Justice H.B. Prabhakara Sastry on what you could do as legal aid, not just lip service and not just putting up banners. Thank you very much, Your Lordship, for having spent your time, traveled all the way from the other end of Bangalore, because Bangalore traffic. And let us take forward whatever he has told us. I request our Dean to kindly hand over a memento to our guest as a token of our gratitude. We are also extremely thankful to Professor Dr. V. Shyam Kishore, Professor and Dean, Alliance School of Law, again traveled from another end of Bangalore, and giving us a small insight about the concept of legal aid and how practical education should be imbibed in what we teach in law schools. Thank you very much, sir. I request our Dean sir to kindly hand over the memento. We also express our grateful thanks to Professor Dr. Sairam Bhatt, a well-known face. Almost we are like friends, like Dean sir said. But nevertheless, to have organized this in association with CMR University School of Legal Studies and CEDA. Thank you very much, sir. And sir will also be addressing you all in our session. And
We're also extremely thankful to our beloved Dean, Dr. T. S. Subramania, for getting us these wonderful resource persons. Thank you very much, sir. Well done. A big thank you to the team, Advocate Vidya Subramani, and all her faculty and student volunteers, well organized, and all the student participants, good, taking down, prepare your report, and let it not remain just for the sake of reporting. Go farther than that. In spirit, the legal aid, literacy and awareness should happen. Thank you very much.